And we welcome the ranking member of the full committee here too. Normally I make relatively short opening statements, but this is a particularly important hearing. It's important because there's never been a time in our history in which getting it right, not just on patents as we've known them, but patents are as they are emerging. I want to thank the Undersecretary for, among other things, clarifying in AI the pathway to patentability. I certainly think that when we look at the ambitious agenda set out by President Trump, he has selected well an Undersecretary to make sure that we can reach that. One of the first actions of Mr. Squires was, in fact, as director, to take steps to move the president's AI agenda and to strongly support it. This meant going above and beyond, and with some changes to the Biden-Harris policy, which came out late in the administration. This thoughtful change, I believe, will bear well for the foreseeable future. But like everything else in AI, I will expect it will not be the last time that guidance will have to come either from the director or, if necessary, from Congress. Squires, that we are pleased with everything that is going on. You had to deal with a clear conflict of interest, but also with a policy that was ambiguous as to where a conflict lies. The particular case does not need to be discussed here because it rose to criminal activity and a dismissal. But let's understand, patent examiners with even a small amount of stock cannot and should not be evaluating a patent that could benefit that company or that stock. That level of conflict of interest now is zero under your leadership, and I want to particularly commend you for that. If somebody had asked me, as someone who has followed the Patent Office for decades, now 180, once nearly 280, patent examiners are technical specialists. They will look at dozens of cases, both sequentially and in parallel. They adjudicate these over a year, so by the time they've been on the job for a couple of years, they may have done 60 or they have brought them to a close, and they seldom have any reason at all not to meet their deadlines. That means they do a better job. The proof of that is that they run about a 12% total reversal, even in part. Meaning, if you lose at the Patent Trademark Office or you win, you can pretty well take it to the bank and either move into Article 3 or move into another place with that patent. But additionally, we have discovered that a full trial that is nearing its 1 year, that is ready to go to decision, can in fact be pulled back and undone. Director Squires, I have to tell you, it is my belief, and it will be my legislative last act if I can, that either will be undone or we will undo it. Once a process, a determination has begun, even if you, at the end of it all, choose to not agree with the decision, to undo it, to in retrospect, undo it, is in fact to have less than the fair process be appeared, and in fact, both parties have spent money in the process. It should be allowed to go to decision. You can then evaluate the decision. That is a particular concern, and it'll be the one that I spend most of my time on.
You recently took an extraordinary and unprecedented action. Earlier this year, the USPTO itself filed trademark applications on behalf of Donald Trump's ill-defined private multi-billion-dollar global project called the Board of Peace. President Trump has declared himself chairman for life of this elusive entity. He's promised billions of dollars from the taxpayers to the board, although Congress has not voted a single dollar for it. And he has secured billions of dollars from mostly corrupt foreign governments, including Saudi Arabia, Kazakhstan, Azerbaijan, United Arab Emirates, Morocco, Bahrain, Qatar, Uzbekistan, and Kuwait. Beyond that, there's not much we know about this shadowy venture. We don't know its basic corporate structure. We don't know whether it's a registered entity anywhere in the United States or in any other country. We don't know who controls the billions of dollars in its bank accounts. We don't know what countries those bank accounts are located in. We don't know who will conduct audits and oversight of the board, if anyone. And we don't know what the president intends to do with this massive, secret, unaccountable slush fund while he's in office and after he leaves. When the Board of Peace decided it wanted to secure a trademark for its name and for its logo, a move that should have required it to identify the legal entity that actually runs it and controls its billions of dollars, you stepped in. You personally filed the trademark applications, allowing USPTO to stand in as a straw trademark holder, cover up for this slush fund that appears to put both billions of US taxpayer funds and billions in payments from foreign governments into the pocket of the chairman for life, Donald Trump, who will control it. The president set up a board that likely violates both the foreign and the domestic emoluments clauses, and now you're helping to run the operation, as far as we can tell. What's more, I'm not sure that either you or the Trump administration realize what you're confessing by filing a trademark application. You're admitting that the Board of Peace is not a legitimate governmental body, but rather a commercial enterprise set up by President Trump. Our trademark law began when the Supreme Court struck down a trademark law that applied to any and all organizational designations. The court ruled that Congress could do so only under the Commerce Clause. So when Congress passed the Trademark Act of 1880, only to marks used in interstate commerce. The modern version of the Lanham Act makes clear it only protects trademarks used in interstate commerce. Section 1052B specifically forbids the registration of any insignia of the United States or any state or municipality or any foreign nation or any other governmental body. So by filing for a trademark, you're admitting that the Board of Peace is not really a governmental entity at all. It's a purveyor of influence operating for profit with apparently $1 billion admission fee, at least that's what's been reported in the press. A money laundering scheme to pocket the billions, all made in a global shakedown in the name of peace. Now, as far as I can tell, the USPTO has just 9 trademarks. 4 are various logos for your office, some of which read USPTO. Others have the full name of the agency written out, IS Patent and Trade Office. 3 more are for the phrases "Go for real" and "You're smart, buy smart," phrases that were part of a public awareness campaign that the USPTO itself ran with the National Crime Prevention Council. The mysterious Board of Peace, which has no organizational relationship, I believe, whatsoever to the USPTO. So by agreeing to act as President Trump's phone a friend and using the PTO to register a trademark on behalf of a third party, it would seem you're violating a cardinal principle of the Lanham Act, which explicitly lays out in subsection B that only, quote, a person who has a bona fide intention under circumstances showing the good faith of such person to use a trademark in commerce, who may request registration of the trademark. That's quite a problem for the agency whose role it is to administer and police the registration of trademarks and to administer disputes about them. One can only imagine this decision will get challenged, and there will be litigation over the mark that you have now claimed as your own for the PTO before your agency, which is charged with being the neutral adjudicator of disputes about trademarks. The only reason anyone ever registers a trademark is to prevent competing uses. Why would the Trump administration tell you to file for this registration except to suppress anyone else's trademark related to the word peace? The field is crowded with existing registrations by other educational purveyors of global peace. To give a few examples I found online this morning: World Peace Table, World Peace Network, Project Peace, Peace Vision Global, Global Peace Initiative, Global Peace Foundation, International Peace Center, Peace Network, Peace Action, the Peace Trust, Greenpeace. Any one of these organizations would have a strong case to sue for cancellation of Trump's Board of Peace trademark on the grounds that it dilutes and infringes their own pre-existing trademarks for peace facilitation services. And also, of course, that this mark is not registrable at all, since it purports to identify a governmental entity and not an organization in interstate commerce. Not only would you have to decide whether Trump has a defense to prior users' opposition to his marks, you would have to rule on any offensive use of trademark law by Trump against any of the other groups. Let's say he moves to attack Greenpeace for infringement of his commercial trademark or opposes registration of any new organization that uses peace in its name. Who would adjudicate this? You would, your office. You're both the owner and you're the judge of any rights that you have as an owner against anyone who wants to identify their organization with the word peace. This is not just a disreputable use of the trademark registration process, it's the first step in giving Donald Trump and his subordinates a monopoly on use of the word peace, to make the very notion of peace unthinkable if it departs from control of the new big brother who now owns it. If President Trump can't win the Nobel Peace Prize he craves, because he plunged us into an aggressive war of choice in the Middle East. Now he'll just own the word peace instead. I wrote to you last week, Director Squires, asking about this elusive entity, an unprecedented, baffling situation. If there's a reasonable explanation for the USPTO's conduct here, we'd like to hear it today. Because if you simply filed on behalf of the Board of Peace as a favor to the president, then that's a serious problem. A decision like that doesn't just drag the USPTO into covering up for a slush fund that may violate both the foreign and domestic emoluments clauses. It's bad for the integrity of our trademark laws. When people lose faith in the fairness and objectivity of our system, it begins to fall apart. So I'm not just troubled that you may be violating the basic trademark rules. I'm troubled that in violating the rules to help Donald Trump, you may be acting as a political operative in a way that will destroy our neutral system for regulating source-identifying trademark rights. The trademark system is designed to protect everyone. If applicants think that the rules change for the wealthy and the politically well-connected, they're much less likely to believe the system can work for them. I look forward today to finding out how you justify your agency registering a commercial mark for this alleged governmental entity, if that's what it is, how you intend to resolve disputes with the dozens of past and future registrants of peace organizations, and what you intend to do to restore the professional, nonpartisan reputation of the USPTO. Thank you, Mr. Chairman. I yield back.
You're now recognized.
Thank you, Mr. Chairman. Chairman Issa, Ranking Member Johnson, Chairman Jordan, Ranking Member Raskin, members of the subcommittee. Good morning, and thank you for this opportunity to discuss the USPTO's operations and initiatives. I thank President Trump for his confidence in me to lead America's Innovation Agency and for his steadfast commitment to intellectual property, reaffirmed yet again with his National AI Policy Framework released on Friday. It's also the honor of a lifetime to serve Secretary Lutnick, a phenomenal leader with boundless energy and unparalleled experience, himself an inventor on over nearly 500. I'm honored today to provide the subcommittee an overview of the USPTO's recent activities and accomplishments. America's Innovation Agency has two foundries. For patents, we have America's Invention Agency, and for trademarks, we have America's Branding Agency. And together, we function as the Department of Commerce's central bank of innovation. Every unit of intellectual property we put into circulation is a potential job, a new business, a competitive advantage, an investable asset, a life-saving drug, all flowing into the real economy, into the real world. And at scale, American ingenuity means national prowess and global reach. I can't thank the USPTO's highly educated and talented workforce enough for their dedication and commitment. They are the best in the world at what they do, because quite simply, they are. And none of this would be possible without the fee-setting authority so thoughtfully provided by Congress, allowing us to operate like a business, maintain long-term financial stability, and achieve our statutory mission. We also greatly appreciate the continued authority to spend anticipated fee collections, which lies at the heart of our U.S. global leadership. We look forward to working together to maintain both it and our global lead. Indeed, we lead today because our founders did the extraordinary 2 centuries ago, enshrining IP protection into our Constitution, and with it, the American experiment itself, the American experience itself. Last month, I told the head of the UK IPO how our constitutional charge allows us to lean into AI, to quantum, to medical diagnostics, wherever the onrush of technology is going. His candid reply, I know, wish I had that. Think about that. The very empire we won our independence from, 2 democracies, 2 outcomes, but only one clearly atop the IP world today. That's why it's incumbent upon the USPTO to have an America First IP agenda built atop the unique legacy our founders bestowed upon us. And we're doing exactly that with the urgency of now. As I'm before you today, our first priority was slashing the unacceptable backlog by 50,000. Another 100, and with your continued fee-setting authority, choking backlogs will be a thing of the past, and improved quality, a confidence indicator. I'm confident because we just announced our first agentic AI trademark classification tool. 5 months of manual searching is now a 5-second outcome. In patents, our AI search assistant delivers a top 10 list of prior art before the first office action, providing quicker pathways to allowance. And across both, AI fraud detections helped us purge plus baseless filings in just under a year. You see, tools will become our examiner's superpowers, supplying them with a cadre of agents to deploy as they see fit. Congress affords us discretion, and our North Star to its exercise is always both the letter and the spirit of the AIA, balancing, as instructed, economic impact, resource efficiency, and the integrity of our IP system. We are restoring balance and fairness on both the front end with eligibility determinations.
How did you come to file those trademark applications for the Board of Peace?
Thank you for the question, Congressman. We came to file, I had them filed in response to a immediate cyber squatting land grab of the domain name. And for those who are unaware of the term cyber squatting, it's like identity theft.
Were you acting as a lawyer for the Board of Peace at that point?
No.
So in what capacity were you acting?
Well, the Board of Peace, this is exactly the issue, and I'm glad to have the opportunity to explain it
Please.
and respond to your letter. The Board of Peace has not yet been formed as an international organization. And the cyber squatters, 8 minutes into the president's speech announcing it, registered the domain name. And so
Is it a public entity, the Board of Peace, or is it a private entity?
At this point, I'm not sure if it's formed or not. We acted as a custodian so that they could have the mark.
How did you come to act as a custodian for that trademark?
Under 35 USC Section 3, it's my responsibility to advise the president through the Secretary of Commerce on matters of national security and all matters of intellectual property.
So the Board of Peace is a public entity? It's a governmental organization, even though Congress has not created it? Is that right?
Sir, I don't know the status of whether it's an entity formed or not.
Okay, well, how did you get involved in it? Did the president call you about the cyber squatting incident?
No, the president did not call me. It came up through several organizations about the cyber squatting and the action needed to be taken to
When you
address the
talked
harm.
about the cyber squatting, you noted that there were lots of other organizations that were already using some variation of peace organization, peace committee, world peace, and so on, right? There are dozens of them. I mean, I found them this morning just on the way in.
Well, again, reference was made to Shakedown. This was registered, this particular Board of Peace, and without that, you don't have the
You
ability-
registered that?
No, no.
Oh, who
A cyber squatter.
You don't have to talk about a cyber squatter. There are dozens of other groups that have peace in their name, right? Where does your legal authority come from to file trademark applications on behalf of this Board of Peace, whether it's a public or private group?
It comes from the combination of 35 USC 3 and 35 USC 2, Lanham Act, and in your opening statement.
Well, wait, do you usually act as a custodian for the intellectual property rights of other entities, or is this just for President Trump?
This was to protect the name Board of Peace as the entity gets booted up, to act as custodian in a very narrow capacity with a bona fide intent to use the name, and then it's a intent to use application.
Who has
to be
the bona fide,
transferred.
the USPTO, what are you going to do with it?
In the very limited services that we define there, which is fraud, prevention, misuse.
Is that a service you offer to all American citizens? In other words, if I'm thinking about maybe creating a group one day and we might want to have a trademark and I'm afraid somebody else has a competing trademark, you will go ahead and file the application for me?
My responsibilities are, again, under 35 USC Section 3 to advise the president on matters of national security.
So this is a matter of national security? Okay, let me ask you this. You've emphasized today, and rightfully so, the importance of people who are applying for patents or trademarks to pay a fee, because yours is a fee-paid office. How much does it cost for someone to seek a trademark? When you applied for that trademark for the Board of Peace, how much does that cost?
It's not an expensive fee, depending upon...
The website says $350, is that right?
Generally, yes.
It's not expensive. Okay. And one of the able lawyers on my staff just passed me this. You filed a petition on January 21st, 20 Peace. Then you granted that petition the very next day, which underscores the bizarre conflict of interest you're in, now acting both as a representative of the Board of Peace and also Trademark Office that's going to pass upon the petition. But why did you seek a waiver for the $350 for the Board of Peace, and why did you grant it?
The waiver was sought under the particulars of the intent to use application as the custodial filer, and I did not grant my own application.
As I'm reading it, you filed this on the 21st, and then you approved it on the 20th.
Well, I would like to see the document to which you're referring.
Okay,
but,
we will get you those documents. Are you saying you would not have approved it had you seen it?
I'm saying I don't recall this particular situation,
Okay.
but I do believe it's in my authority.
Okay, it was approved by Dan Vovanisi, but your signature is on the petition, and I guess,
yes.
Why did you request that waiver of the for the Board of Peace?
Again, given that this is going to be an international organization, given the situation with the intent to use and the bona fide limited scope that we had, I made that petition just as I signed the application, and it was granted
Okay, and then
by someone
finally,
else.
from submitting an application unless they're the owner of the mark or the legal representative of the mark. Were you representing yourself as the owner of the mark or the legal representative when you filed the petition?
No, we are very clear. It's on a custodial basis. We are not the owner. It will be transferred to the entity once it's formed.
Okay, well, you're listed as the owner on the petition, both for the waiver and also the application. So that's the way the Lanham Act works. In other words, if I'm asking for your advice, could I?
Mr. Chairman and Director Squires, under prior practice, decisions were made by the PTAB. When an IPR petition was filed, a three-member panel of expert administrative patent judges decided whether to institute a review under the AIA's, quote, reasonable likelihood standard. You first centralized power over discretionary denials in the director in March of 2025, and then by consolidating authority over institution decisions in the director as well. As you know, we only have 5 minutes here. These two questions really have either a yes or no answer. Do you intend to continue this policy instead of restoring that responsibility to a three-member PTAB panel of expert judges? Would that be a yes or a no?
I can give you a maybe.
Okay, we'd like to know further as you ponder this. Under your current policy, I'm wondering whether you consult with at least 3 PTAB judges before making an institutional decision.
Yes.
Okay, that's helpful. What concerns me is not just the centralization of the authority and therefore potential for abuse, it's that the office now regularly denies requests for PTAB review of patents that may have been improperly granted without giving written explanation. I have an example. Is denial. It's 2 pages and it just says no. Here's the way it used to be, which is yes or no and the reasoning, and people knew where they stood. So I'm just sort of wondering, under the standard operating procedure manual, it says the significant writing assignments in AIA proceedings include decisions on institutions, and it goes on and on. The expectation that there would be a detailed explanation for whatever the decision. I'm just wondering in these bare bones summary denials where someone would find the reasoning in the arguments raised by petitioners. And do you think that practice is really consistent with principles of transparency and fairness?
I do think so. There's a body of over 600 decisions that have been issued, and where there's matters of where we have something to say or a particular story needs to be told, we do issue those decisions and opinions. So to provide guidance. The Revo line of cases has been one where there's been inconsistent claims. It has multiple touch points, of course, in the office, but I'll give you one example. We have launched a what we call ASAP, AI-generated pilot program, which takes the prior art, gets it to the applicant before the first office action. So literally, the examiners and the applicant are on the same page with the prior art beforehand. So they have some agency as to what they want to do. They can make an amendment. They can, marshal their arguments or decide this is not going to go well. We're not going to waste our resources and refile with something, direct the resources to something that might be more productive. So we're trying to get information in the hands of people at the soonest possible point where they can do something with it and have people be on the same page. On the eligibility side, we've formed a 101 working group, and we are starting to deploy AI agents to assist in some of the areas where there are the thornier issues to decide on and to give some assistance to the examiners. Always will be human in the loop. The larger vision is, as I mentioned in my opening statement, to have the examiners be able to manage cadre of agents, deploy them as they see fit to their cases, and be able to do thousands of hours in the hundreds of hours time, but still remain expert in their field and be just as equipped as the private sector applications coming in.